This court is now in session.
All right, thank you, Ms. Peoples, and good morning. Welcome to the Tennessee Court of Criminal Appeals docket for today here in Nashville. We're operating under unusual circumstances based on the pandemic. We much prefer being in person in the courtroom with the attorneys and the clerks, but in the interest of safety and attempting to prevent the spread of COVID, we are operating on Zoom today, and we're being streamed, as I understand it, live on the YouTube 10 Courts YouTube channel. So interested observers, of course, can utilize that. Everything else will pretty much be the same as if we were actually in the courtroom. And I'd like to introduce my colleagues. To the left of my screen is Robert Holloway from Columbia, Tennessee. To the right on my screen is Judge Tim Easter from Williamson County. And my name is Robert Wiedemeyer. I'm from Davidson County. And we're the panel for today's docket. And the rules are, as usual, 20 minutes. Each side has 20 minutes to argue their case. If the appellant wishes to reserve some time for rebuttal out of that 20 minutes, please let me know when you start your argument, and I will assist in you keeping up with your time in that regard. We are grateful, I should add, to the folks at the Administrative Office of the Courts and to our clerk, Jim Hivner, and his assistant clerks for making it possible for us to operate in this manner and keep the cases in motion and being heard during a very difficult time. So the members of our court appreciate the efforts of all these folks. And we also appreciate the attorneys being willing to appear and argue in this fashion. We have read your briefs. We have not looked at the records to any extent at this point. Of course, we will after the cases are argued, but we are prepared in as much as we have read the briefs. So I think that's all the preliminary matters. I know we had some technical difficulties on our last case, so hopefully those are resolved. And ready to call the first case, please.
State of Tennessee versus Daquan H. Fields.
All right. Mr. Collins, are you ready?
Yes, Your Honor. David Collins of the Nashville Bar. First, I'd like to save 5 minutes for rebuttal.
Certainly.
Secondly, I only want to argue the sentencing phase of this brief and just rely on the brief for the sufficiency of the evidence argument. The appellant submits that the language that prohibits the enhancement of a sentence by use of something that is an element of the offense, where that appears in the statute, the appellant would argue, is not controlling what the legislative intent was. Where the Tennessee Code Commission decides to codify a particular act should not affect the legislative intent of the statute. Further, we would argue that perhaps the reason for the addition of this language was to avoid a double jeopardy situation, which is what we think we have here by what the sentence imposed by the trial court was. Trial court relied on the 1985 case of State versus Blackburn. That case basically held that since there was no language in either the felony murder statute or the statute that listed the felonies, then codified at 392402, that prohibits sentencing for both crimes, that a trial court was free to do so. They followed a more, I guess it'd be liberal French philosophy of law, says that which is not prohibited is allowed, as opposed to the more conservative German philosophy of that which is not allowed is prohibited. So the reasoning was, since the legislature had not affirmatively put language in either statute, saying you couldn't sentence for both crimes, the same was allowed. Like I said, this was in 1985. But in 1989, the legislature enacted the new Sentencing Act, and that language that prohibits enhancement of persons serving a sentence by use of something that constitutes an element of the offense for which the person was convicted was prohibited in that language. Now, the judicial branch has granted the legislative branch a very generous presumption, being that it's at the time it passes the law, it's aware or it has knowledge of its prior enactments and knows the state of the law at the time it passes the new legislation. And that was said as recently by our Supreme Court in the case of Moody versus Snead in 2000. So we would argue that you should conclude in that 1989, the legislature was aware of the Blackburn decision when it enacted the language prohibiting the use of something that's an element of the offense to enhance a sentence. Also, a reading of Blackburn reveals that the double jeopardy question was not raised as an issue in that appeal. And appellate courts, while they can if they want to, they rarely address an issue that wasn't raised by the pleadings. I don't think anyone would argue that the underlying felony, such as in a case like this, aggravated robbery, it's an essential element of the crime of felony murder. Remember, this appellant was also charged in count 3 of this indictment with first-degree murder, and the jury returned a verdict of reckless homicide. So the only thing that convicts this defendant of murder is the felony murder statute, which is rooted in and based on the aggravated robbery, which is also contained in count 2. It's the same identical conduct that constitutes the underlying felony charged in count 1 that supports the conduct or the charge in count 2, the indictment of aggravated robbery. We would argue that to impose a consecutive sentence of 12 years to the life sentence that's automatically received upon conviction of felony murder is to sentence the defendant twice for the same act or the same conduct. If, in cases such as this, we would argue that the counts must merge for sentencing purposes. We're not saying that a jury can't find them guilty of both. Certainly, I can't think of short of a super case of jury nullification where they would find a defendant guilty of felony murder and then acquit him on the aggravated robbery count. I don't think that's a legal possibility. But just as in this case, had the jury found him guilty of both counts 1 and count 3, first-degree murder and felony murder, they would have merged for sentencing purposes. In fact, in this case, the trial court merged the reckless homicide, lesser included count of count 3 with count 1 for sentencing purposes. You can only, and the merger thing, you can only kill an individual once, and that gets to the root of the merger question. We would argue that in this case, the clerk of the MAPCO, Timothy Rhodes, could have only been robbed, and the proof was he was only robbed once. So it is our argument that while the jury could find him guilty of the aggravated robbery count, independent of the felony murder count, and while the trial court could possibly impose a sentence for that offense, that those sentences would have to merge together into one judgment. In support of this, we would argue that if the 89 Amendment clouds the issue of what the legislature intended, then the rule of lenity breaks in favor of the defendant, and the merger should be granted. And that's basically our argument on that issue.
Are there any Tennessee cases that have decided this? It seems like it would be a fairly common issue that would come up, but I haven't.
I couldn't find any, and it's outside the record. But the judge's clerk told me she couldn't find any either. when this issue was raised. I raised it, of course, in the motion for new trial, and so she was instructed to research it prior to. And the only case anybody came up with was the 1985 case, where, like I say, the double jeopardy question wasn't addressed. And even there, it says you can sentence for both. We're not saying you can't sentence for both. We're just saying that they have to merge, because otherwise you're sentencing the defendant twice for the exact same conduct of aggravated robbery.
How is it the exact same conduct when you have a clerk that was robbed and a truck driver that was killed? How is that the exact same conduct?
Well, I'm talking about the aggravated robbery part being an element of the offense of felony murder. That if you allow the consecutive sentences, then you're allowing the consecutive sentence, in effect, enhances his life sentence. And that isn't, the aggravated robbery is a necessary element of the felony murder. You can't have felony murder without the underlying felony. And in this case, it was the same aggravated robbery.
So the fact that you have two separate victims should not apply to this analysis?
I would argue no, because the victim in the essential element is the same. Mr. Rhodes was the same person robbed in both counts. And then that is the same conduct. And that is the aggravated robbery is the necessary element to get the life sentence on the felony murder.
All right, Mr. Collins, you still have your rebuttal time remaining.
Thank you.
I assume you were finished with your
Yes.
opening argument. All right, so General Watkins, you ready?
Yes, Your Honor. Thank you very much. May it please the court, Austin Watkins appearing on behalf of the state of Tennessee. It's the state's position, Your Honor, is that Mr. Fields' judgment should be affirmed. First, because the sufficiency of the evidence is more than adequate to support the convictions here in this case. And then second, there's nothing in the language or structure of the sentencing scheme that would prohibit consecutive sentencing for felony murder and the underlying felony. Your Honor, moving to this second issue regarding consecutive sentencing, what the trial court did here was under TCA 4035-115. That's a consecutive sentencing statute for when there's multiple convictions. It's a discretionary consecutive sentencing. The trial court looked at this case after determining the length of the sentence for each separate offense. It found that Mr. Fields qualified as a dangerous offender, and then it decided to impose consecutive sentencing. That's what it did here. What the state understood as Mr. Fields' argument raised kind of in the principal brief is that this was essentially a statutory interpretation issue, that under the preceding section of the sentencing statute in 4035-114, which controls enhancement factors, there's language there kind of in the preface of the enhancement factors that essentially says, an essential element of an offense should not be used to function as an enhancement factor as well, right? Like the legislature doesn't want the state to be able to kind of double dip and double punish an offender for something that helped make the offense through the element and then add, raise the length of the sentence within the appropriate sentencing range. That's what 114 is about, Your Honors. And the state kind of understood the defendant is trying to overlay that prohibition onto the discretionary consecutive sentencing statute there in 115 behind it. And there's just no case law to support that interpretation of the sentencing statutory scheme. And there's just no reason to think that that would be something that the legislature intended. Determining the length of a sentence is a completely separate component of a sentencing determination from whether or not to align those multiple sentences concurrently or consecutively. And so as to the kind of double jeopardy aspect of this raised by the defendant now and in his reply brief, Your Honors, the Blackburn case specifically deals with this issue. Now, it was prior to the 1989 Sentencing Act, but the first sentence of the case is this issue. The issue in this case is whether the constitutional prohibitions against double jeopardy forbid imposition in a single trial of dual convictions for felony murder and the underlying felony. I mean, it squarely dealt with this issue, but just with a different sentencing scheme. Your Honors, the state's position is that there's nothing in the 1989 Sentencing Act that changes the nature of kind of what is happening here, that it would have changed its intentions with regard to punishment or with, double jeopardy considerations, when in the end, what we're dealing with here is two separate crimes. And I think, Judge Easter, you really brought that out when you're questioning, appellant's counsel here, is that we have the murder of a witness, of a bystander, and we have the robbery of a gas station. So the idea that, a defendant should not be punished for two separate offenses is just, is a little bit contrary to common sense, and what there's just no basis to think from the statutory structure or its language that the General Assembly would have intended for there not to be a punishment for the murder and a punishment for the separate robbery as well. And for example, if there had not been a felony murder charge, if the reckless homicide conviction had stood on its own, I don't think the defendant would argue that the reckless homicide couldn't be run consecutive to the robbery. So the fact that it merged with the felony murder here really just prohibits double punishment for the murder. But this is two separate crimes. Even though it's part of one course of conduct. But there's nothing here, Your Honors, from the intent of the General Assembly to prohibit under the sentencing scheme itself consecutive sentencing here, or that would defeat kind of the double jeopardy analysis that looks to whether or not, if there are separate elements for two offenses, whether or not there's indication from the legislature that it intended for there not to be double punishment. And so we kind of just have a completely different situation here because there's two separate offenses. So, Your Honors, if you have any questions specifically on the nature of the sentencing scheme or the Blackburn case, I'm happy to go into that. But we think even though there's not a specific case dealing with this issue under the 1989 Sentencing Act, that there's really no reason to do anything different than what the Blackburn opinion has laid out. The enhancement factors and the prohibition about double counting an essential element of the offense when determining the length of a sentence under subsection 114 is completely separate from whether a trial court has the discretion to align multiple sentences for multiple convictions concurrently or consecutively, assuming that the criteria are found under 115. They're just two separate inquiries. So, any questions from Your Honors on that?
Mr. Watkins, did you find any Tennessee cases affirming consecutive sentence of felony murder and predicate felony?
You're wrong. The Blackburn decision does that, I believe. I mean, it authorizes double conviction and separate punishment specifically for felony murder and the underlying felony. That's my understanding. I don't remember specifically the offenses there in Blackburn, but I think it's dealing with it. It's just under the pre-1989 statutes. And I'm sure there are unpublished decisions where, this court and the Tennessee Supreme Court has affirmed consecutive sentencing, but not necessarily addressing this specific issue. I don't believe I cited any in the state's case. We kind of viewed this as a little bit of a novel issue of statutory interpretation as presented by the defendant.
I was because doing research during your argument is a little hard, so I'm just reading it quickly. But the Duran test, I don't know if you ran across it. It may be pre-89. I have to look. But it was I think an aggravated child abuse, a felony murder, and I think it's the Supreme Court Justice Wade found it affirmed consecutive sentence. I read it quickly. I don't know if Mr. Collins found that or not. Obviously, I need to read the case more thoroughly.
Your Honor, and the state's position is just simply under a double jeopardy analysis or statutory interpretation analysis. Again, I mean, they're two separate offenses. And so the fact that having the underlying felony is part of what makes the murder felony murder But this is not a situation where, you know, the defendant is being double punished for the same conduct. I mean, it is two separate offenses, even though the fact that the murder occurred in the course of the perpetration of the robbery is what, you know, changes it, makes it a, you know, essentially makes it eligible for lifetime punishment. You know, that's one thing. But the reality is when we're talking about whether, you know, it's permissible for him to not only be sentenced into like a life sentence and get 12 years for two separate offenses, you know, just like any other two different offenses under 115, the trial court, where applicable, has the discretion to stack those. I mean, there's just no reason why the General Assembly in murder cases wouldn't feel that, you know, that would be appropriate, for example, under the circumstance of this offense.
Well, the State versus Durantes is a Supreme Court case from 2011, 331 Southwest 3rd, 370. Now, I'm reading from the head notes, and I haven't had time to read the entire opinion, but it basically affirms consecutive sentencing for aggravated child abuse and felony murder resulting from the aggravated child abuse. I don't know if either one of you found that case for some reason.
I think, you know, and I think that would be appropriate for the court to rely on that. I guess, you know, to be very generous to the defendant, I didn't see any case law specifically arguing that the language in 114 kind of should be overlaid onto the consecutive sentencing discretion in 115, which is essentially, I kind of understood the defendant's argument as saying, hey, look, if you're punishing a defendant for felony murder and then you kind of for the felony murder and for the underlying felony, if you run those consecutively, that's a very literal enhancement of the sentence, and you're double counting the element, which is prohibited under 114. I mean, that's what the state understood a very literal statutory interpretation argument to be. And I didn't see any cases dealing with that specifically. I don't know if it was raised particularly that way in Durantes, Your Honor. But I think it's pretty clear if you look at the two different sentencing schemes, the 114 prohibition on double counting, it is directed at a single offense, and it has to do with determining the length of the sentence. So, you know, the state would kind of just reject the idea that consecutive sentencing is actually a sentencing enhancement within the nature, you know, of the structure of the sentencing scheme. So I didn't find any specific cases that I recall dealing with that particular statutory interpretation argument, Judge Holloway. So it may be out there. It also may be that if you look at Durantes, it pretty clearly, by implication, you know, would approve of what happened in this case. And so did the trial court in this case make the appropriate findings to justify consecutive sentencing, go through the factors? Your Honor, I believe the trial court did. I don't believe that the appellant or the, you know, when he was in the trial court or now has challenged the Wilkerson findings or the defendant's dangerous offender finding by the trial court. I think I dropped a footnote about this, but I don't specifically remember what language was in the record from the trial court on this issue. But I believe that issue just is not before the court about whether, you know, whether the consecutive sentencing determination under 115 was accurate. I think the defendant has kind of acknowledged that other than this prohibition on enhancement, that it was appropriate in this case. And so that's my recollection, Your Honor, is that the trial court made the requisite findings in order to justify its consecutive sentencing determination. Okay, I appreciate Your Honors. Thank you very much. If you have any further questions, let me know. Otherwise, I will let Mr. Collins have his rebuttal.
All right. Thank you, General Watkins. Mr. Collins, you have your entire rebuttal time to use if you wish to do so.
Yes, sir. We would argue, again, going back to the sentencing hearing, there was no reason to sentence him on count one. That had been automatically imposed after the jury's verdict. So the life sentence was there. We would argue, and maybe it is a literal interpretation, but that the legislature stated its intent that a sentence shall not be enhanced. And enhanced, if you look up the dictionary definition of it, is to increase or make more severe.
Mr. Collins, let me ask you, which sentence are you arguing was enhanced? The felony murder sentence or the armed robbery sentence?
Well, I guess it'd be the felony murder sentence because he already had the life sentence.
Right.
So the imposition of the consecutive sentence was
Well, the consecutive 12 years, correct?
Right.
Well, I'm curious then, because it does sound like you may be conflating Section 112, which, as you've indicated, the legislature has determined trial courts, sentencing courts cannot double dip and use an element of the offense
right.
to enhance a sentence. We agree with that.
Right.
How does what you're arguing violate the consecutive sentencing section of 115?
Well, our argument,
Especially if Judge Blackburn went through the Wilkerson factors, which the note in the state's brief indicated she did.
yeah, she did.
So-
I'll concede that she did. Always does. Our argument would be that the prohibition that was included in the 1989 language is an expression of legislative intent that you don't enhance a sentence. And in this case, you would be enhancing the life sentence by utilizing something that constitutes the same element. In other words, the aggravated robbery is the same in both counts. And if I understood the state's argument correct, it was making a distinction on the fact that it was different victims in these different counts. But taking that argument, logical conclusion, then if it had been Mr. Rhodes that was killed instead of the Krispy Kreme driver, then you couldn't run the sentences consecutive because it would have been the same victim. So we would.
Well, I think victim may just be one piece of the facts that makes it different. There is other conduct involved too. The taking of property by force and robbery would be separate elements that would not necessarily be needed for a homicide, a killing. But in any event, I think victim is just one piece of the elements that may be different in the two. It's more of a criminal conduct argument, I believe, that the state was arguing.
Yes, and well, that's our argument, that it is the same conduct that's virtually being punished twice, and that you couldn't have had the felony murder conviction without the underlying aggravated robbery. And
then it sounds like your argument is more of a double jeopardy argument than an enhancing sentence argument. Am I correct?
Yes, it's both, but it's probably more of a same conduct being punished twice argument, because it is the same person robbed in both counts, the same crime described in both counts, the same conduct proven in both counts. And for that reason, we would argue that the double jeopardy clause would prohibit punishing him twice. Now, if they merge, he's not, even though he may receive time on it, if they're unconcurrent, that's still like a single punishment for the same act. In other words, he's going to flatten out his 12 years long before he hits the life sentence eligibility at 51 years. So that doesn't enhance or increase the sentence in that respect. But when you run them consecutive, it does, even though it's a practical matter, he probably won't live to complete either one completely. And I'll rest with that.
Right. Thank you, Mr. Collins and General Watkins, for the excellent arguments and excellent briefs. We'll take the case under advisement, and I'll ask the clerk to recess court until our next case at 1 o'clock.
Thank
This
you.
court is now in recess until 1 p.m.